with this question opened up, I'd like to ask I guess particularly those panelists, but in terms of employment effects, let's put aside a situation where there are unused resources, unused human resources, which is fair to assume is currently the case generally across the country. But where that is not the case, it's obvious that, it seems obvious that if you raise the cost of a particular product, you're going to have less consumption and you will have an unemployment effect. Now, you have those effects from every change that comes from any change in the cost of inputs or outputs and so forth. And economists normally treat that as frictional unemployment. Why is that not the correct way to treat it in a cost-benefit analysis?
That's exactly what they do in the cost-benefit analysis. That's when you aggregate it out. There's the way that you can. You sometimes say this is jobs aren't costs, they're benefits. So basically, like when you shift someone to a more efficient, say, if you internalize an externality, that might result in someone's job being lost, but the idea is that you've moved them to a more productive job. There's some friction there, but that is a problem. I think that the more, and this is maybe something that will happen more in the future, especially during this kind of recessionary time, is to really get into that question that you started with, is are there underutilized resources? And so maybe economy-wide we have that happening. There are certain maybe areas of the country where we have underutilized resources. It turns out people don't really move. It's really hard to get people to move, right? And so they'll just stay where they are. And so that might be an underutilized resource, and that there's an economic benefit to putting them to productive. But it's a very hard kind of analysis to do.
Please correct me if I'm wrong. I have an untutored mind on this, but as I understand Executive Orders 12866 and 13422, you look to market failures as something, as a state of a state that you're looking at to see if there's anything you need to address. Is there anything in the regulatory impact analyses that looks to the pro-competitive benefits and anti-competitive effects of the regulations themselves? And if not, is there any interest in doing that, and perhaps having the antitrust division get involved? And my second question is a little less related to cost-benefit analysis. Since I have regulatory gurus on the panel, I have to ask: do they think that there'll be more prompt letters? Will more prompt letters be issued by OIRA under Cass-Sunstein? Thanks.
Agencies should look at the competitive effects of their regulations. I know it was maybe one or two when I was there that we thought we might bring in the antitrust to the Justice Department. I know I was on the career staff of OIRA in the 80s, and we did seem to engage them more back in the 80s. And that might be something, if the new administration asked us, that might be something to recommend. I don't know how to comment on the prompt letters. Michael might have some ideas.
Yeah, I think it's hard to say with the prompt. Obviously, it's hard to say with the prompt letters. He hasn't been on the job for very long, and so there's not a big space that we can get a trend line off of. My guess, if I was just gonna bet, I would take 60-40 odds that there's going to be more prompt letters.
It's easy to do more than I did. So I did none.
And John Grant started off, he did a bunch, but then it kind of tapered off. That would be you might expect that, is that right at the beginning, Cass might have some ideas that he's been building up from all of these years, and he'll put them out there, and then eventually he'll run out of ideas. So that's a very unlikely proposition.
He's also a very he's a cooperative person, so it may be that he has ideas, but he shares them privately rather than in a public letter.
That's what I was going to say is, prompt letters are sort of the public way to put an idea out there in a way that's guaranteed to get shot at, and to look somewhat adversarial with the agency you're trying to work with. Picking up the phone and getting things done behind the scenes tends to be more effective. So even if there aren't prompt letters, that doesn't mean that he's not doing quite a lot. It's just not a very good measure of activity.
Yeah. On your anti-competitive question, I think that Susan's response to that, I think, really gets to the heart of why you don't see that as much now, is that the kinds of regulations that we're engaged in and thinking about a lot now aren't the same kinds of regulatory regimes that we were thinking about in the 80s. We were thinking about, deregulation in the context of where we're actually like regulating an entire industry like the airlines. And so there were these huge competitiveness kind of contexts to all the variety of regulatory regimes that we had. We've deregulated a lot of those, and now we're really talking about these kind of economy-wide regulations where there very well may be very strong competition consequences, but it's a lot harder to tease out what they are. And so I just think analytically it's so difficult. There's probably not a lot of attention that's devoted to it.
I have a question that goes back to the delegation question. As you mentioned, the constitutionality problems about delegation have been resolved for the Supreme Court, at least, through the specification of an intelligible principle, which is a pretty loose standard, as it turns out, in reality. But I'm wondering, given that, as I recall, there was a fair amount of hostility from Congress to cost-benefit analysis in the past, I'm wondering to the extent to which it's true that some kind of net benefit standard is actually is going to be an intelligible principle in these delegations. And if not, doesn't that mean that the administrative agency simply imposing the intelligible principle on the legislation when it uses cost-benefit analysis, which would thereby really raise constitutional questions on the delegation side?
That sounds familiar.
That was a gambit tried by the DC Circuit in ATA, which was unceremoniously discarded. So that is to say, to invite the agency to adopt criteria constraining what appeared to be a huge delegation. But the Supreme Court clearly had no interest in that device, which to be fair, had problems.
I actually think that your question also gets to the Riverkeeper case. So the question of whether cost-benefit analysis is an intelligible principle to make decisions, I think, is distinct from the question of whether the agency has authority to do cost-benefit analysis. Because you could say that the Congress's intent wasn't for the agency to do cost-benefit analysis, and now they don't have an intelligible principle, but it's kind of like a two-stepper. But I think under Entergy, there's going to be pretty broad discretion for the agency to do cost-benefit analysis, and that's kind of a separate question of whether it's an intelligible principle. It probably is, just kind of in a general way, and so it seems like that's going to be a hard one to argue.
Just a quick question on cost-benefit analysis. The critics of the cost-benefit analysis, Susan, some would argue it does not take into consideration certain resources that don't have market values. And this is one of the things when I was at EPA in the Office of Water we struggled with, was certain critters in the stream that obviously the agency wanted to pass laws to protect would not be factored into the benefits of a rule that was being considered. Is there a role? For many years, continued valuation was, bantered about, but in many cases, CV analysis has been despunked because it overinflates the value of certain things that people are willing to pay for. I'm curious, is there room for cost-benefit analysis to contemplate those types of issues?
I like to think of cost-benefit analysis as being one component of a good regulatory impact analysis. And certainly regulatory impact analysis has room for that. In fact, the RIA guidelines specifically says take into account non-quantifiable impacts. And the executive order itself talks about things that cannot be quantified. So decision makers have to make their decisions, and benefit cost analysis is one thing that they look at, and it's an important aspect of how they make that decision. But those other factors also can be laid out in a regulatory impact analysis so that a decision maker can make the best decision possible with the information that we have.